practical application unless you fail. Then your probation can be revoked. You can be then found guilty, sentenced up to 20 years in prison, and that prison sentence would have to be served at least 50% because of the affirmative finding of a deadly weapon. So a lot riding on you doing well. 5 CR 642, the state of Texas versus Andrew Diaz. That's you.
Yes, sir.
Present with Mr. Adams, your attorney and the state's attorney. And does the defendant waive a formal reading of the indictment and arraignment? In this case, can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about April 19th of this year, 2025, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon. You understand what you are charged with here?
Yes, Your Honor.
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement's been reached where you would be pleading guilty and placed on deferred or unadjudicated probation for up to 10 years. And is there any restitution? No. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan in this case?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, Your
How
Honor.
do you plead to this charge? Guilty or not guilty?
Guilty.
So you're pleading guilty voluntarily, and because you are guilty.
Yes, Your Honor.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand
Yes,
what you're charged with? The indictment's been read to you. Are you ready? Do you understand it fully? You are guilty of the crime charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer here. All true.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes in this case. Pre-sentence report is waived.
Yes, sir.
I will follow this agreement and find, Mr. Diaz, you are pleading guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, Your Honor.
There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt in this case. However, the court is going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. If you do well, it can be shortened to 1/3 of it. There will be terms and conditions of probation, including anger management, which helps you make decisions under crucial decision-making situations. And that will help you. Also, the court, even though you have not been found guilty, so long as you follow these terms and conditions of probation, the court finds there is sufficient evidence to support an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. It will not have any practical application unless you fail. Then your probation can be revoked. You can be then found guilty, sentenced up to 20 years in prison, and that prison sentence would have to be served at least 50% because of the affirmative finding of a deadly weapon. So a lot riding on you doing well. So are you going to do well?
Yes, sir.
Okay, it's up to you. Anything else? That is all. Please talk to the probation officer and